everybody, and welcome to today's webinar, the COVID-19 Legal Health Check. I'm John Hovey. I'm the Special Projects Consultant here at North Metro Denver, SBDC, Small Business Development Center. And for those of you who might not be familiar with the SBDC, our center is based at Front Range Community College. We serve the North Metro Denver area, and we're part of the Colorado SBDC network, over 14 full-time centers. Our mission is to help existing and new businesses to prosper and grow by providing free one-on-one counseling. We also provide low-cost and no-cost training, such as this one today. You can find us on our website, northmetrosbdc.com. And I'd encourage you to visit there and make a consulting appointment today. I'm excited to get right into our topic today. We're presenting what we call the Business Legal Health Check, and it's to help you who are reopening now in the wake of COVID-19, and it's going to be presented by our legal consultant, Margrit Parker. Margrit's an attorney. She runs her own practice, and her resume is just, her background's really impressive. She's included on the 2020 Colorado Super Lawyers list. Congratulations. And she works in the field of contracting, business planning, risk management, employment law, you name it. She does it all. So I'm really excited to have her on board today. Before I turn this presentation over to Margrit, a few housekeeping items. We'd ask that you please keep your microphones and cameras off during the webinar, and that's so that we have the smoothest, fastest connection for you today. And a few features on your webinar panel. If you don't already see it, I'll find the button and push it, but there are two handouts for the presentation today. One is the slides that we'll be presenting, and the other is the Business Legal Health checklist that you're going to learn about today. And you should find those in a handout panel in your sort of webinar control panel on the right side of the screen. There's also a question box, and you can type in your questions at any time that they occur to you. We'll be compiling those questions, and we'll do a Q&A at the end where we can make sure that you get your questions answered. All right, I think that's enough from me. It's over to you, Margrit. Thanks.
All right, well, thanks, John, and thanks for inviting me to this webinar. As you can see from this first slide, it's the COVID-19 Legal Health Check as we resume business operations. And before I dive in, I was asked to give a little bit of an introduction about myself and my background. I am a CSU grad, for those of you who are CSU fans. I do have a background in horses, in the horse industry. So after college, I worked in the thoroughbred horse industry in Kentucky before coming back to Colorado. And then after law school and a couple of years of working for judges in the court system, I went into private practice. And I worked for a downtown Denver law firm for almost a decade, doing litigation, defense of professionals, and directors and officers' liabilities. So if you think of folks who are licensed and insured professionals like physicians, lawyers, business owners, and accountants, you name it. I represented them in defense of lawsuits and also licensing complaints before regulatory bodies. But over the years, I began to spend more time in doing and enjoying the work of the business side of things, from entity formation to contracts and employment advising, kind of like in-house counsel, but on the outside. And for those professional clients that I was representing in litigation, as well as veterinarians and horse industry folks. So I decided to move my practice closer to home and set aside the litigation to focus exclusively on the business side of things that I enjoy doing. So that's where I am now and why I am here. So let's move. Let's see, I want to make sure I'm advancing my slides here. Today's roadmap, a little outline of where we are going today in our conversation. And ultimately, it's my goal that you walk away with a better understanding of how you might want to shape your strategy or modify your strategy if you're already putting one in place for resuming your operations from a legal perspective and the practical steps to accomplish that. So first, identify goals for resuming operations. Why are we even here? Why do we care what our goals are at this point? And then a checklist and developing actionable items. And then we're going to focus on the first 4 items in that checklist because it's about an 8 or 9 item checklist. Today, we're going to focus on building your team, public health and safety compliance, preparing for claims and liability exposure, which is another way of saying risk management, and planning for future business interruption. But first, preliminaries always have to say this in a legal presentation. Every situation is different. So don't rely on this presentation as legal advice for your particular situation. This is especially true in the time of COVID-19 when things are changing so rapidly. Part of my presentation is already out of date because I reference a public health order that was the 5th amended, and Friday night, the 6th amended public health order 2028 came out. So things change quickly. Other preliminaries, John already mentioned this, but you're going to, well, and I guess you've got it in your presentation here as attachments, but if you need an email with a copy of the slides in the handout, you can get it. Our contact information will be on these slides. So why are we talking about our goals for resuming operations? Why are we doing this? Well, for many people, there's a public health component, wanting to ensure that what we're doing is safe for all involved, not just our customers and public, but also our employees. And also business survival and continuity. There is a level of risk management involved in wanting to make sure that even if somebody is injured or something goes wrong, that you survive that. There is, of course, the question of what if I disagree with the extent to which COVID-19 is actually a health threat, or the extent to which the government has restricted business operations. When you guys signed up for this presentation, you were asked to give us some questions for me to answer up front, and I had already planned for this, but there was a question about, how enforceable are the governor's orders, because they are really unprecedented with the frequency with which they come out. So in my opinion, from a business perspective, I would argue that unless you are willing to put it all on the line and engage in litigation or actively in defiance or contrary to a public order, a business doesn't really have the luxury of disagreeing with these orders. There are businesses out there that are challenging these orders either in practice or in court, and I'm sure you're all well aware of the Castle Rock restaurant that opened over Mother's Day weekend, only to be shut down by the state subsequently. And from what I understand, that restaurant has now filed a lawsuit alleging constitutional violations. There's also the barbershop in Greeley that opened a few days before it otherwise could have under the new safer at home orders. And within a day or so, it had been closed down. Now the news reported that it wasn't closed down because of its violation of the stay-at-home order, but that it was discovered once it became, in the news. DORA discovered that it had not renewed its license and had been unlicensed for several months. Now, I personally searched the DORA licensing database and couldn't actually find the shop or the owner listed, and maybe I have the spellings of their names wrong. But the lesson here is if you're going to challenge something, an order, you ought to have all your ducks in a row otherwise, because some technicality may overshadow or diminish the principle on which you're trying to stand. And also another example of a challenge that's going on is the United States Supreme Court recently denied review of a couple of cases, one out of California and one in Illinois, regarding restrictions on houses of worship. The one in California, the Supreme Court actually issued a written decision about that. And it was a split decision with Justice Roberts being the swing vote, and then the traditional conservative branch of the court dissenting. So really, what if I disagree? How much do I really want to comply? Another way of looking at it is all about your comfort with risk. Are you risk averse or are you risk tolerant? How much risk are you willing to take on? And that may guide the decisions that you make. Unless you want to be a test case, you probably need to embrace these orders and directives moving forward. All right. So the next segment is our checklist and developing actionable items. And I know that I have struggled with thinking about this over the last couple of months, that there's so much to do and there's so much information. The web and the news are flooded with information and changing laws and changing guidance. So hopefully today we can start to think about and compartmentalize the concrete issues to address and tackle them one by one. Some things that might help to narrow your focus. So if you have employees, or if I should say, if you do not have employees, that eliminates a huge to-do item from your list, because there are a vast array of employment laws and changes and modifications and compliance issues when it comes to COVID-19. If you have an office or a workplace where your employees come to work, that's a whole nother section of issues. And if you don't have that, then that's an issue, a section of information or action items that you don't need to undertake. If you have a storefront or a place where you are face-to-face with your clients, that's another major category. Of course, if the answer to all of these questions is no, you probably aren't significantly impacted from a health and safety compliance perspective, and you probably may not even be on this presentation, or on this webinar, but those are some kind of big picture benchmarks about things that require a lot of effort and attention. All right, so a proposal for a checklist. I've created a list of about 8 categories of items that a business should consider in evaluating and re-evaluating regularly while the pandemic continues. That's not to say that you don't come up with more on your own, or somebody else might propose a different set of topics, but it's whatever works for you. The idea is to think about everything that could possibly impact your operations. So the first 4 I have here: build your team and circle of support, public health and safety compliance, preparing for claims and liability exposure, planning for another surge, and then we have employees, business succession, planning for loss of key individuals, review of all loans and contracts, and financials and tax compliance. Now, these last 4, we're not going to spend a significant amount of time on. I did mention employees a little bit already, that there's a vast array of issues ranging from compliance with changed laws, leave and pay requirements, health checks, etc. But with business succession and planning for loss of key individuals, what I'm getting after there is what happens if you or a key person in your business gets sick, has to quarantine, self-isolate, a temporary loss. How are your operations plan to address that, or if there's a permanent loss? So looking at your entity documents for business succession as well as just operational. And then on the loans and contracts, that's looking at, through the lens of COVID-19, what kind of interruption events might constitute a default? What kind of negotiations might you want to make so that it's easier to move forward financially? Are there ways that you can renegotiate contracts? Are there new terms that you might consider adding. I know folks are starting to, when they enter into new contracts, revising their force majeure clauses. Those are now at the forefront, and people are starting to figure out how to incorporate what we know now from COVID-19. Financials and tax compliance. The laws keep changing on this. As many of you know, the PPP loan program, a new law was signed on Monday, I believe it was, changing again the forgiveness rules. I mean, for the benefit of business owners, but still, it's a lot to keep track of. And so staying on top of financials and ensuring tax compliance with filing deadlines. So those are the 8 topics that I came up with as a starting point for a checklist. All right, so the first 4, these are what we're going to look at for the rest of this presentation. All right, building your team. Can you do all of this alone? And should you? I would venture to say the answer is no. If you have employees, your team internally is going to be vital to you completing everything that needs to be done, because there's a lot to do. And not only that, if you include your team in this planning process and implementation process, you're likely to get better buy-in and a better result, better performance on these measures. Importantly, your professional relationships and advisors. So you look internally, but also externally. And what I'm talking about here are folks like your banker. They'll help you with loans and issues related to that. Your insurance agent and broker. That person is going to be able to help and sit down with you and look at all of your present insurance, what is covered, what is not covered, what might you consider getting coverage for if there's something that's insurable related to COVID-19 going forward. If you haven't had those conversations, this might be a good time. I mean, these aren't necessarily things that we shouldn't be doing every year, but there's just heightened awareness of the things we should be doing on a daily basis with respect to COVID-19. Your accountant, your payroll company is going to be on top of all the wage-related changes for employees. Your financial advisor, legal counsel who can help interpret orders and guidance, and also perhaps help write things like liability forms, things like that. I also include your industry association here because of a good example that I saw recently, not a client of mine, but I want to use the example of swim schools. So, in Colorado, and I'm sure elsewhere, we have indoor swim schools where, they have a pool and they give lessons and things. Well, there was concern about where do they fall in the categories of all these closures and safer at home and stay at home, because they're not really a traditional outdoor pool where it's just chaos and lots of people, but a more controlled environment. And so from what I understand, the swim schools around the state got together and worked together to help communicate with the state and the governor, and got additional guidance and consideration to make sure that their situation was addressed, and they felt like they could interpret it in a way that allowed them to open in a measured way sooner than perhaps otherwise they would have. But also important in that example was that these swim schools worked with their local health authorities too, because it's the local health authorities that ultimately are going to be monitoring this. So, industry associations have always been touted as something important to be a part of, and this provides a good example, because you can not only look to your peers to help advance your cause on a greater level, but also for practical guidance of, you're all in the same boat, how are other people dealing with certain issues? and being able to see what other people are doing or share what you are doing and come up with best practices. Okay, so the next item on our checklist, public health and safety compliance. So I will say just right off the bat, I'm not going to read through the lengthy public health order that's currently in place, because it probably wouldn't be a great use of your time, and every situation is different. It's better to start with a concrete fact pattern or issue and then read the order to evaluate how that particular situation applies or doesn't apply and what categories it falls into. But generally speaking, what are the directives and guidance that we need to be looking at? So you start with the governor's executive orders, which we're all now becoming very familiar with. So those orders don't actually provide the practical roadmap. What happens then is that the Colorado Department of Public Health and Environment takes the executive orders and then issues a public health order that sets out specifically the steps to be taken to implement the executive order. Then the third thing that I've been looking to is Colorado government's interpretive guidance. And what I mean by that is primarily the websites of like the CDPHE, because they will oftentimes have guidance that tries to simplify and explain what's in those public orders, health orders, and it gives you insight into how they're interpreting it and what businesses can be open, what can be open with restrictions, what cannot be open. Sometimes this website lags the orders. I've found times where the website is not as up to date as the public health order and contradicts it. So you also have to take that into account. Importantly, local public health authorities and governments. Local authorities can implement more restrictive measures than the state, but if they want to operate more leniently than the state's orders, they have to obtain a variance first. So look to your local public health authorities for their orders and their guidance. There are also many of them, probably all of them, are spending a lot of time trying to disseminate information. So, from where I'm located, I'm located in Firestone. The town of Firestone has been sending out emails to businesses with informational stuff, variances for outdoor seating for restaurants. Boulder County, Larimer County, all of those that I've been looking at, they have lots and lots of information online. The other place to be looking at is the CDC and OSHA, because the CDC is where by and large people are looking to and considering as the authority on safety measures. And OSHA, of course, provides workplace safety guidance. Some things that I also wanted to comment on, requirements versus guidance. It's sometimes not clear whether in these orders something is a requirement as opposed to we strongly urge that you do this. So check that carefully, because that could impact what you decide to do. But it doesn't necessarily mean that you will, if something's only recommended, that you decide not to take that measure, but still consider what is appropriate for you and your risk mitigation. Many sectors or industries are called out on these public health orders and executive orders, as you all, I'm sure, well know, but examples would be personal services like salons. Basically, personal services are businesses where the service that's provided cannot be provided at a distance of 6 feet or greater because it requires cutting hair or a massage or whatever that may be. Another sector delineation as examples would be personal recreation and outdoor recreation. Those kind of came into being with guidance in the last week. Sometimes it's not clear what category you fall into because they can't think of everything. They're moving so rapidly with all this stuff. And I'll give you an example. Equestrian activities. one could find examples that might fall into more than one category that's called out on these orders and guidance. So for example, therapeutic riding, if you're familiar with therapeutic riding that provides equine assisted therapies to people with disabilities, many times that service requires people to be less than 6 feet from the individual that's being served on the back of the horse. You have to walk alongside the horse with your arm on that person. So the question becomes, is that a personal service? Is that a healthcare service? It could depend. And then other kinds of equestrian activities could be considered personal recreation. And then yet again, other kinds of equestrian activities could be considered outdoor recreation. For example, guided pack trips or trail rides. So it really, really is circumstance specific. And I would venture, if you're going to be doing significant amount of activities where you have uncertainty and questions, open questions about what other people will interpret your activities as, it might be worthwhile to proactively contact your local public health authority, just like the example with the swim schools. Let's see. Another example of differentiation, local guidance can vary. For face masks, Boulder County, there's a face mask requirement for individuals 12 and older. Larimer County, the face mask guidance is 2 years old and older, and many people are saying it's a requirement. But when I read it, I was like, is it really a requirement or is it really a strongly urge? So that's another open question. Another example of a variance would be workplace occupancy. So Larimer County obtained a variance to operate a little bit differently and before some of the reopening measures that took place. And my read of it is their occupancy limits are different in that it's based on a square footage in the workplace, not straight numbers. So you'll often see occupancy requirements on the state level talking about 25% occupancy or 50 people, whichever is less. Well, Larimer County's, when I last read it, is based on square footage. So as long as people can be, I think it was within 28 square feet, have a bubble around yourself. As long as that's met, then that's okay. And that could be a more lenient measure. So those are some examples I wanted to call out on these directives and guidance that we might be looking at. So how do we put this stuff into place once we've researched all of this? I would venture to say that it is very helpful to designate a key person whose responsibility is to constantly monitor changes and also work on implementation in the workplace. Again, this is if you have employees. In fact, Public Health Order 2028, which is now the 6th amended, the 5th amended at the very least, had a requirement for workplaces with employees that there be a workplace monitor. I suspect the 6th amended order still has that in there. As an example of why the constant monitoring of developments is important, between Saturday, May 30th and Thursday, June 4th, there were 4 new executive orders, 2 new public health orders, and multiple new guidance documents on places of worship, outdoor recreation, and personal recreation. And since then, there's been at least 1 new public health order. So it's unprecedented and rapid, the amount of changes that are happening in real time. The other thing from a practical perspective that I strongly believe will help with success in this endeavor is communication. Communicate and educate your employees and your customers. You gain understanding, buy-in, collaboration, and compliance, better compliance when people understand. Even if you have employees that maybe don't buy into the underlying premise, discussing with them and bringing them into the process may help them at least understand and acknowledge and appreciate it. Also, practically speaking, written procedures and checklists, putting stuff in writing can be very helpful and very important. And the reason I say it's a good segue is because it's also very important for risk management. The spread of COVID-19 is likely inevitable unless you live in New Zealand, which apparently has declared that they are free of COVID-19, at least at present. And just as it's inevitable that it's going to spread, so are claims likely to be inevitable. Claims and suits are already being filed for failing to comply with safety precautions. So for example, there's been news of a class action lawsuit filed against McDonald's by employees seeking compliance with guidance. And the emphasis here is on enjoining them to make McDonald's apparently comply with measures that they allegedly are not, as opposed to somebody's already been injured and is seeking recovery for that. There's also a number of board cases being filed against physicians and medical providers, for example, for allegedly failing to comply with safety precautions. So things are already happening. You can also find advertisements online from personal injury lawyers already, asking people to, be aware of and have you contracted COVID-19 and what was it due to. So it's out there and it's probably going to happen. And these claims can come from employees and visitors alike. All right, so the question then becomes, well, really, how strong of a claim can anybody really have? So let's do a little bit of a Law School 101 torts class. Typically, these claims are going to be negligence claims. So let's talk about the elements of negligence. The first question is, do you have a duty to the claimant? And we can assume that there is some level of duty, but the question is, who establishes and defines what your duty of care is? And right now, pretty much everyone is looking at the CDC and state guidelines. So even if you disagree with them and think that they are not appropriate or warranted, there is probably going to be an argument that you had a duty to comply with them if you were ever to have a claim against you. So that's the standard of care that could be applied to you in a case. The next element that they have to prove, and they have to prove each of these, there's going to be 4. So you have duty and then breach. Did you breach your duty? Were you negligent? And then third, was the person injured? And did they actually get COVID-19? It seems silly to even say that because, why would they sue or bring a claim if they didn't actually get COVID-19? But historically, there are cases where someone lost their case or it was dismissed because they failed to adequately allege or establish that they got the underlying illness in question. And then finally, what ties all this together is causation. So even if you owed a duty, you failed to carry that duty out, and that person was injured, they still have to show that your failure, your negligence caused that injury. And this is where there may be a lot of fights over. Because how can, the first question is, well, how can you prove that you got COVID-19 in my store? You've been to 10 other stores in the past week, or you live at home with several people. How do you know that you got it here? So causation is going to be a big question. But I've been trying to think of ways that it might become easier to prove, and maybe there's a super spreader event, as they they talk about where say in a store, a large number of people who frequented that storefront all got sick around a similar period of time. Maybe the causation question gets easier. I don't know. We'll have to see it play out. So the bottom line is that risk mitigation measures can help defend against one of these claims, and that's why we talk about risk management. So I have some examples here. I was just trying to think about whether I should talk through all of them, but there's a couple of examples here. There was a claim against a cruise ship for contracting meningitis, and that claim failed because they didn't adequately allege that the cruise ship was negligent in carrying out its duty of care to the cruise ship customers. By contrast, there was another case against a resort that did move forward or succeed because there was evidence that the resort knew about an E. coli outbreak, but it failed to act. And so there's evidence that it was aware of a problem and failed to take measures to mitigate further injury. And so that case was allowed to proceed. So that gives a good example of, here at this point, everybody in the world knows there's a risk of COVID-19. If your duty of care is to take mitigation measures and limit the risk of exposure to your customers or your employees, and you don't do something about it, their claim may be stronger. All right.
So Margaret,
Yeah.
hello, hi. I actually have some questions that have come in that are relevant specifically to this issue of liability, which I think is front and center for a lot of our small businesses, especially brick and mortars that are reopening. Question came through, are there any specific requirements for retail businesses with walk-in business? Again, you touched on these, but are there any specific legal liabilities related to that? And what minimum standards to meet to reopen and prevent later employee lawsuits exist? So is there anything specific to retail?
So yes, so there's kind of two parts to that question. One is as to employees and one is as to the general public, is what I am gathering, if I understand that correctly. And so you would need to look at the state's public health order, which gets amended periodically. We're now at the 6th version of it. It's 20-28. And there's going to be, then you have to figure out where does your business fit in those categories, and retail is in there. And the other thing to look at would be the CDPHE's website, where it has guidance about identifying specific types of businesses and what they must and must not do. The public health order has about 6 or 7 appendices. So they're like outlines for specific things that have to be done by a business for it to be operating in compliance with the order. So once you figure out where you fit, then you can basically just take those steps and implement them. My recollection for retail is that they have to implement specific measures to make sure that customers stay apart, from one another, like taping the floors and things with distances. I mean, there's a number of things that can be done. And then as to employees, the public health order also speaks to things that should be done from an employee safety perspective, and the measures that should be taken. So for example, health checks and temperature checks, and eliminating all common area places where people are more likely to congregate, or limit usage of common things like in a kitchen area, spreading out meal times, avoiding, if there is a meal time, being at least 6 feet apart. There's a number of things that are called out in the public health order to address that. So I mean, the standards are going to be set by these orders predominantly, but then on the employee side, there's another larger layer beyond just health and safety, but employment laws, labor and employment laws. So I mean, that's beyond the scope of this presentation, but that's something to be aware of too. Hopefully that answers that question somewhat satisfactorily. I know it's unsatisfactory because I didn't give you a list, but you really do need to just go and read the order because that's the ultimate source. Are there any other questions right now?
No, that's it for now.
Okay. So now that we understand that risk mitigation is a good defense to a claim, what are the measures that we can take to prepare for claims and liability exposure? The first is that I have on my list, and this is in no particular order of importance, insurance. And I have this starred and highlighted because there's going to be another slide about it. Second, compliance with orders. Just talked about that quite a bit. Documentation of the measures taken. And if you recall, when we were talking about compliance, one of the last things I had on there was written policies and procedures. So that's where the documentation piece comes in. Again, here, warnings and waivers. And this fifth one, continuing to make available remote and outside service. And what this one is really getting to is providing alternative options for coming into a storefront. And I borrowed this from something else that I read because I thought it was an interesting point. And that is, if you have a customer who can choose to do curbside pickup or go into a store, if they later make a claim that they contracted COVID-19 in your business, they're going to have to face the issue of and explain away why they opted to go inside instead of curbside service. So if you're providing an alternative, they then have to make a choice and decide what level of risk they are going to accept. So I thought that was an interesting point, in addition to just making remote and curbside service still available because there's still so many restrictions on business. It could also be a mitigation measure, a risk mitigation measure. Then finally, legislation. And I bring this up because I'm sure, as many of you know, both on the federal and state level, there's a lot of legislative activity going on, both on the side of trying to find ways to limit liability exposure to businesses, but also to protect workers and other folks who are, frequenting businesses. I was just on a call this morning where I got to listen to a lobbyist talk about the current Colorado legislative session. And there's a number of things, whether they will pass or not, but there's legislation out there to provide increased protections to workers. There's a sick leave bill for providing for paid sick leave that I don't know if that was directly related to COVID-19, but I suspect it probably gained momentum, and it didn't hurt that it came in this environment. But it sounds like there's going to be a requirement for up to 6 days per year of paid leave across the board. It apparently, and I haven't read this yet, but apparently it even will apply to nonprofits. So staying on top of legislation, and if you really, really care about it, getting with your industry groups or other organization to evaluate and follow or actively pursue or oppose these things. The other thing I don't have on here, but it's just important to keep in mind is don't forget about everything else that you do to the exclusion of COVID-19 safety measures, because there's a lot of other important things you do to keep businesses safe and operating smoothly. An example that a colleague of mine gave me, because he has clients in like the ropes, the outdoor ropes courses and things, is, if you spend so much time cleaning and sterilizing the harness equipment, have you considered whether that impacts the integrity of that equipment and whether it will last or fail? So don't forget about everything else that you do that's important to the exclusion of COVID-19. All right, so I highlighted some of these three items, so we'll talk about them a little bit more. So insurance. Review your insurance coverage and which policies may or may not respond to injury claims related to COVID-19. So right off the top, there's workers' compensation, general liability insurance, but talk with if you have questions about what your coverage is, what is covered, what is not covered, what might be something that you could obtain insurance for, that is something to talk with your agent or broker about. There are attorneys out there who specialize in insurance, but unless you have, a specific issue or a dispute already existing, the first place to go, I think, would be to your agent or broker. So you have somebody with a good relationship that you can really work with on that. As a side note, obviously, this presentation or this part of it really is focusing on injury, but there's other insurance coverages that are going to respond potentially to non-injury related claims, for example, employment, business interruption. So it's just a good time to review the whole picture. All right, so another risk mitigation measure, documentation of preventive measures. I can't emphasize enough that it is Exhibit A at trial. Having done defense work for nearly a decade now, it is way easier to convince somebody of the truth of a document than it is, relying on the credibility of a witness. You'd rather have the documented evidence to establish that something took place. And I just snapped these photos from a restaurant that I went to this past weekend, just as an example of the documentation and the signage that they have out. And so this document here, the sign was right next to our table and said, here are all the things that customers must be doing. Don't let your kids run around, etc. And then on the tables, they had little boards that you could flip over to say it was clean, it had been sanitized, or it was dirty, it had not. So documentation. All right, warnings and waivers. So the signage you just saw, it's notices of the risk and general measures taken and the precautions requested or required of customers. And as I'm sure many of you know, one of the more recent executive orders expressly authorized that businesses can require patrons to wear masks. Whether that was just more of a symbolic statement as opposed to, something enforceable or, change something that couldn't happen before, I don't know. But signage and notices of what you're requiring of people, it at least puts them on notice, even if, at this point you think, are you living under a rock? You know what's going on out there. Put a sign up anyways and just inform people. The next level of protection in the world of warnings would be waivers. Do you want to get a release of liability form? And that would be a contract between you and the customer, that the customer is saying, in exchange for being able to partake of your services, I release my ability to sue you in the future for negligence, like for if I contract COVID-19. These liability forms are becoming more and more prevalent. They have their place, but I caution, but use them with caution because they are closely scrutinized and they're unenforceable in certain situations. So I'll give you two extremes. Especially in Colorado, outdoor recreation is very much favored and looked upon favorably. So under Colorado law, liability waivers for recreational activities are upheld as enforceable. But in certain situations, such as essential services that people must get, they're going to be frowned upon and probably unenforceable. So for example, a physician can't require a patient to preemptively waive the right to sue for malpractice later. So you have to think about where on the spectrum you are in that, and also whether it would just be distasteful to your clients to even require a liability form. But if you decide to do that, they need to be carefully drafted. And I would suggest this is something where legal counsel really is vital to actually having a form that is most likely to be enforceable if it was ever challenged, because they do have various nuances and requirements that if not done properly, just a poorly written one may not be enforceable. And importantly, a liability form does not eliminate all exposure. You can't contract away intentional wrongdoing or willful wrongdoing by somebody. So even if you do have a liability waiver, it doesn't create immunity. Okay. So the last thing we have here is planning for another surge or business interruption. What are some of the things to be thinking about? Insurance comes up again. Thinking ahead to business interruption insurance. Can you get it? Is it something that makes sense and will cover the things you're actually hoping it will cover? Looking at your contracts and business relationships with an eye towards what might happen if there is a surge. Are there things that you might want to renegotiate now, or new relationships you want to form to better bolster your ability to survive in the future? And then use your recent response measures to prepare your playbook for the next time. What worked, what didn't work. I often think that recency in evaluating something helps to create better plans for the future. So if I reevaluate a project that took place last week, I'm more likely to come up with a new and better plan if I think about it now, as opposed to 3 months from now, because I won't remember it as well. And these things will all help ensure less legal problems. You can't avoid them, there's no way, but the idea is to mitigate. So that's it for now, and that's my contact information, and thanks to the SBDC for hatching the idea and putting it together. There's their website, and they have a YouTube channel for replays of all of their presentations that they have put on. So with that,
Thank you, Margaret. You're hired for being on our promotions and marketing team. you aren't going to have enough work coming out of this presentation, my goodness, I have to just thank you so much. And I think the message for small business owners is incumbent to pull in your people from the very first slide, is assemble your team, but also remain, we have to stay educated, even with the rapidity and change of information coming down the pike. That isn't going to be a defense. It sounds like, in terms of, there's just too much information for me to keep track of. Although we don't know, right? We don't really know what's going to be happening in terms of precedents. But I think this was super helpful, and at least helping business owners know the right questions to ask. So I want you to share again your website. In case folks are interested, they can go to North Metro to book an appointment with you, but they can also go directly to your site to help with assembling some of these documents and internal policies.
Sure, and it's a lot of work. So I understand that small businesses may not have the budget for the amount of legal work that it would take to put this stuff together. Like, I'm helping an organization on a pro bono basis, a nonprofit group, and I've probably spent close 15 to 20 hours on just an aspect of it, not even the whole thing. So some of it may just be financially out of reach, and hopefully some of this you can pick and choose and decide, well, I want a lawyer to help with this, or I want an accountant to help with this, and find ways, and then decide, okay, well, I'm just going to go with my own with some of the other pieces of it.
And just so folks know, they can you can book an appointment with Margrit at northmetrosbdc.com, and she is available to at least help you frame the nature of your question. So she can't give formal legal advice through North Metro. She would need to be retained privately for that, but we do offer those services. And also in the handouts window, you can download her presentation plus the checklist that she put together, which I think can be really helpful. So before I share some upcoming programs, Margaret, do you have any last words of wisdom for our clients? Well, thank you so much. It was really helpful, and we look forward to some follow-up presentations as the legislation and precedents come out that will help clarify, because it's unknown territory right now for everyone.
We're all learning together.
We are, definitely. And so to that end, I wanted to remind folks that tomorrow we have a small Talking Business episode focusing on small business and this new legislation that Margaret referenced, which is the PPP Flexibility Act, which has adjusted some of the policies regarding forgivability of those PPP loans. We have our lead consultant, Karen Patel, will be interviewing Lauren Kometz, who's also one of our consultants, who's a CPA, who will be talking about general accounting best practices, especially in light of this new PPP legislation. So tune into that. That's tomorrow at 11. And then on Thursday, we have a new series called Market Matters, and that's with Adrian Hovey and John Hovey. Will be talking about market trends and what to be paying attention to as a small business owner. That's at 11 o'clock on Thursday, and you can register for those on our website, North Metro SBDC. So with that, I want to thank you again, Margaret, and have a great day, everyone.
Bye.